Hey, I'm firearms attorney Gilbert Ambler, and I am back today to talk about more pistol brace information. And the reason we're doing another pistol brace video is because there's been so much misinformation out there on the internet, including from other attorneys, and I want to set the record straight on 3 myths that I've seen. Okay, first myth that I've seen is that there is no issue with an imported brace pistol other than the possibility of 922R. Absolutely not true. There is a separate law that says it is a crime to possess a brace pistol if it came into the country with the brace already installed. We're going to talk about that. I'm going to give you the code sections so that you can look it up yourself. Second myth we're going to dispel today is the idea that if you did have a 922R violation, meaning you were the one who assembled a pistol into what the ATF now classified as a short-barreled rifle, and your pistol was an imported pistol, that you can't go back again. We're going to dispel that myth. And then the third thing we need to talk about is the sneaky way in which the ATF can still use your information against you, even with the statute that everyone's been citing lately, which is 26 U.S.C. 5848. That is not an absolute bar. All right, let's dive into it. And before we dive into it, if you have not yet hit that subscribe button or shared our videos, make sure that you do both for us. That way you and your friends can keep getting this important content. All right, first thing I want to talk about is the fact that there is a law that makes it a crime to possess an imported braced pistol if the brace was already installed at the time it was imported into this country, okay? Now, bear with me because we're going to have to look at 3 separate code sections to reach this conclusion. We will post these code sections so that, maybe over here, we will post these code sections. That way you're able to look up the law yourself. I want you to be able to look at the law yourself, okay? First code section we need to understand is 26 U.S.C. 5861K. All right, I'm going to say that again, 28 U.S.C. 5861K. And 26 U.S.C. 5861K says that it shall be unlawful to receive or possess, again, possess, a firearm that has been imported in violation of 26 U.S.C. section 5844. Okay, so it's unlawful to possess a firearm that has been imported in violation of 26 U.S.C. 5844. Now we need to know what firearms have been imported in violation of section 5844. So we jump over to section 26 U.S.C. 5844. First thing we need to do here is we need to define firearm, because there is a definition of firearm in 26 U.S.C. 5845A, which defines firearms for purposes of this title as NFA firearms, including short-barreled rifles, barrels with a barrel length of under 16 inches, or weapons made from rifles, okay? Now, let's go back to 26 U.S.C. section 5844 and understand what types of imports are prohibited, because we now know that the definition of firearm is an NFA firearm, including an SBR, which is what the ATF says a braced pistol is. 5844 says you can't possess a firearm, think SBR, you can't import a firearm unless it meets one of 3 criteria. The 3 criteria are: number 1, if it's for government use, okay, your firearm which was imported for your personal use, theoretically not for government use, okay, for the vast majority of individuals. Second criteria where you might be able to import an SBR is if you are importing it for science or research purposes. Keep in mind, however, if you're going to argue a science or research purpose, that specific science or research purpose had to be listed on the Form 6 when the weapon was imported. And of course, for guns that were just sold to average citizens at most gun stores, did not have any scientific purpose listed, okay? So probably not scientific or research purposes. Third category would be as a sales sample or for testing for a licensed manufacturer, importer, or dealer. Again, if you're a civilian and the brace pistol is in your hands, it was not imported for that purpose. So what does that mean to us? It means that if you had an imported pistol and it came into the country with a brace already installed, that means that the ATF thinks that it was not a pistol that was imported, it was a short-barreled rifle. And 26 U.S.C. 5844 says generally you can't import a short-barreled rifle unless you fall into one of those exceptions. We understand why our firearm probably does not meet any of those exceptions. And now if we are in possession of a firearm that was imported in violation of 5844, now we fall under 26 U.S.C. 5861K, which makes it a crime punishable by up to 10 years in prison. Okay, so we need to understand it is potentially a crime to possess imported pistols that came into the country with the brace already installed. The interesting thing about this is the ATF, although there's plenty of things in the final rule that the ATF talks about their enforcement discretion for, they don't talk about enforcement discretion for this. I know there are going to be people that jump into the comments and say we're just fear-mongering with this information. My intent is not to fear-monger, it's simply so that you can understand what the law says and what the ATF could potentially prosecute you for. If you trust the government and you believe the ATF isn't going to prosecute anybody for these violations, that's on you. Totally entitled to that opinion. I want you to understand what's possible. It's possible that they come after you for an imported firearm that already had the brace installed. Okay? That's myth number one we need to head off. Myth number two. We talked a little bit about 922R previously, okay? It is a crime to assemble with more than 10 imported parts a non-sporting firearm, a firearm that the Attorney General doesn't find suitable for a sporting purpose, okay? And when I say firearm, the firearm that we're talking about is a semi-automatic rifle that is not for a sporting purpose. 922R doesn't apply to handguns generally. It applies to semi-automatic rifles that are not suitable for a sporting purpose. It's a crime to assemble a semi-automatic firearm, semi-automatic rifle not suitable for a sporting purpose. So if you had a pistol that was an imported pistol with more than 10 foreign-made parts, more than 10 relevant foreign-made parts, and you install a brace on that pistol, you are making, in violation of 922R, a firearm, okay? A semi-automatic rifle, because that's what the ATF says it is when you put a brace on it. You've made a short-barreled rifle. 922R establishes a 5-year penalty for the criminal violation of this assembly. Now, I see lots of people saying, well, what happens if I did this? If I had a imported pistol, I had something like a CZ Scorpion, and I put a brace on it, I assembled in violation of 922R, does that mean I can't go back to it being a pistol again and get rid of the brace, get the brace out of my possession? I've seen some opinions out there that you can't go backwards because that would, quote, be a firearm made from a rifle. And that's not true. We talked about this in one of my prior videos, but I'm going to talk about it again. ATF has a ruling on this point. That ruling is industry ruling 2011-4. And 2011-4 says that if the firearm started life as a pistol, if it starts life as a pistol, it can go to a rifle and back to a pistol again, and that's totally okay. Of course, you have a 922R violation at the point that you assemble, if it is an imported pistol that meets the other criteria, but nothing says it can't go back again. So if your firearm started life as a pistol, you added the brace, nothing stops you from removing that brace. And then what you need to do is you need to keep your mouth shut about having ever put a brace on it. Because if you start talking about the fact that you added a brace and they could prove that the firearm met the 922R criteria at the point you assembled it, you would be admitting to a crime. So you need to keep your mouth shut about that. You should not be talking about that. Definitely don't talk about that online. Final myth that I want to bust today is the concept that the ATF can't use anything you provide on your Form 1 application against you because there's a federal statute on point. Federal statute, everyone's been pointing to this statute. 26 U.S.C. 5848. And I agree, 26 U.S.C. 5848 says that generally the information provided on a Form 1 application that is evidence of a crime that occurred prior to the application or concurrent with the filing of the application can't be used against you. But you need to pay attention to this language because it stops it from being used as evidence if the crime occurred prior to or concurrent with filing. The issue in this situation is that this situation is different than almost any other NFA application, okay? Because any other NFA application, if I wanted to build a Form 1, right? I wanted to Form 1 a silencer and make a silencer, I would apply and receive Form 1 approval prior to making my silencer. And I say silencer because that's what the law calls it, not a suppressor, okay? So Form 1 prior to being in possession of the item. The issue here is that everything has been turned on its head. ATF says you are in possession of an SBR, but don't worry, go ahead and register and we'll forgive this violation. What's that mean? It means after filing, but before receiving approval, there's a time period where you are still in possession of an unregistered SBR, and although the ATF says they have enforcement discretion not to come after you, the law doesn't stop them from coming after you, because they can't use the information prior to filing, but they can absolutely use information they gain after filing. There's actually case law on this point, okay? U.S.C. Hunter, it was out of the Eastern District of Michigan in 1994. The court looked at this section 5848 and they said, sure, you can't use the information on the actual application as evidence against you, but nothing stops the ATF from using that as a jumping off point for their investigation, going out and collecting separate information, which they could then introduce against you. And in this scenario, you've provided passport photos, photos of the weapon, fingerprints, your address. You've given them an awful lot of information to use as a jumping off point for an investigation. So if they were really devious, could they do something like call you up after you filed the application? Remember, the protection ends at the time of the filing of the application. Could they call you up and say, hey, we're just trying to confirm some of the details on your application, and as soon as you start confirming those details, you're now turning over, providing evidence that is not protected by 5848? I think that's possible. Again, do with this information what you will, but understand that that federal statute, 26 U.S.C. 5848, is not an absolute prohibition on them using information they learn against you, okay? So, although it's helpful, it is not the end of the story. If you enjoyed this content, and again, I just want to go through the 3 myths quickly. Number 1, there is certainly a possible criminal penalty for possessing an imported brace pistol that came into the country with the brace already installed. We need to worry about that. Number 2, when we talk about a 922R violation for assembling a semi-automatic rifle that uses 10 or more imported parts, and you had the 922R violation because you added the brace to the imported pistol that fits that definition, nothing stops you from removing the brace, getting rid of it, and of course keeping your mouth shut about the 922R violation. And number 3, let's not be quite so confident that 26 U.S.C. 5848 is a total bar to our being prosecuted. All right, if you like this content, go ahead, hit that subscribe button, share it, make sure your friends learn all about it.